The corporations problem from July of 1999 is about as straightforward and simple a securities question as you can hope for. Now, I realize that most American bar candidates have never taken a securities class, and for good reason. This material is some of the most arcane, technical, and also fascinating law that you can study in this country. And that's probably why a lot of people stay as far away from it as they can. Here, we're going to see that applying a good essay technique can make this an even easier question to answer. Have a look at the call of the question. Has there been any violation of the federal securities laws by Sally, Laura, Arnold, Chipko? Well, we can organize our answer to this fact pattern up front, because we know that there are only two federal securities laws that we're being tested on here in California, 10b-5 and 16b. So our little scratch outline will contain 4 Roman numerals, and then letters A and B for each one of them, 10b-5 and 16b. That's it. The answer's now organized, and we haven't even read the fact pattern. So let's read together and have a look at exactly what's at issue here. In paragraph 1, we don't learn anything about securities issues. Here, we really only learn the background information about Sally, our first defendant, vice president for research at Chipko. And we know that Chipko is nationally traded, and we see that Sally has done some research work that could improve microchip production by reducing costs by 3/4. And she knows that this isn't necessarily viable, but it is promising. Now, paragraph 2 gives us a ton of information that's going to be relevant to the analysis below. Laura, our second defendant, is retained for advice on patenting the new technology. And Laura is involved in this conference call with Sally and other Chipko personnel. And we find language that I really appreciate. This information was personally as well as professionally interesting to Laura because she already owned 12% of Chipko's outstanding stock. Well, that's good enough right there to tip us off, so to speak, that we're going to be dealing with a 16b issue. But let me pause for a moment. One of the basic techniques that's present here in the master essay method is we want to be sharp about distinguishing defendants from one another. Here we've got 4 different defendants. They're facing the same basic questions. So we're going to have separate sections on 10b-5 and 16b for each one of them, regardless of their ultimate liability, so that we can distinguish each of these defendants from one another. Next, still working in the middle of paragraph 2, on March 1698, Laura telephones Arnold, our third defendant, who is opposing counsel on some different case, and mentions that her client Chipko might soon be a big player in the microchip business. And then, right thereafter, the beautiful flashpoint of greed, always present in the securities law fact patterns. Sally, Laura, and Arnold all call their brokers and buy Chipko stock at $10 a share. And we pause for a moment to reflect on the majesty of capitalism. Next, in paragraph 3, we learn about the events of April 10, 1998. A financial newspaper reported a rumor that Chipko had developed this breakthrough technology. Within the next 2 days, Chipko stock doubles in price to $20 a share. Chipko had been buying big blocks of its own shares, and it became fearful of continued price escalation. Therefore, Chipko promptly responded to questions from the press about the rumor by issuing a release. We get to look at it. Quote, Chipko has not developed new commercially viable technology at this time. That is true. As soon as the statement is reported by the price fell to $11. And then our final paragraph, on August 20, 1998, after successfully testing for commercial viability, Chipko publicly announced its new technology, and the stock went back up to $20 a share. By September 5, 1998, Sally, Laura, and Arnold each had sold all their shares of Chipko stock at the higher price. It looks like a short swing profit, at least to the extent that they are selling shares that they only recently purchased. Then we get the call of the question. Any securities law violations present? Well, and we get the list of defendants. It's about as straightforward a securities question as you could imagine getting. And believe it or not, probably the most common mistake made by candidates on this question was not to do the simple thing and organize the answer around both statutes. So please turn the page and have a look at the organization that I present in the outline of issues. The most elaborate outlining that I do is for the very first case involving Sally, because here I break down the elements of 10b-5. And even here, I don't break them down into as many paragraphs as I might. I focus on materiality, reliance, and interstate commerce all up front. Then I focus on scienter, and then I reach a conclusion. For all of the other three defendants, the only internal headings that I have are those with regard to the two statutes. And the reason for that is there is no organization to do. These are simple questions, and they require simple and highly analytical answers. So, once again, if you wanted to put a lot of boilerplate into an essay, hoping that would get you some points, there's very little to include here. Sure, you could give a very fancy definition of 10b-5 and 16b, and you would still have an awful lot of time on your hands. Now, as you'll see, I do define these laws, and I do put a fair amount of law into this answer. But this is an answer that emphasizes organization and especially analysis. And the reason is that's where the points are. So let's briefly have a look at this answer, and I'll direct your attention to a few of the better paragraphs. If you are a candidate who's basically using this seminar to learn what you need to know about securities law, this is a question that will do you a great deal of good. I think you'll find that the law is intuitively sensible and the analysis is clear. Your job, should you wish to get a license to practice law, is to present analysis that is as clear and insightful as possible under time constraints. So let's have a look at Sally's potential violations of the federal securities laws. Page 1 of my answer. Notice up front, I give about as truncated a definition of 10b-5 as possible. I say it protects against misconduct in secondary share sales. That's it. Now, let's move on. I indicate also up front in this first paragraph what the elements of a 10b-5 analysis are. Next, I focus on who Sally is. And here, I find a home for the facts. I indicate a lot of the information that we know about Sally. I indicate that she's a proper defendant. I assert that the SEC or some aggrieved stock trader would be a proper plaintiff in a 10b-5 action. Next, I focus on those elements. Materiality, reliance, and interstate commerce are easily met, so I don't spend a lot of time on them. I do find a home for all of the relevant details. If you look at this paragraph under 1A1, dealing with materiality, reliance, and interstate commerce, you'll see I find a home for every relevant factual detail presented in the legal context that will make it plain to you or to a disinterested grader that the author knows the law. Next, we focus on the scienter element, and here, this is where the conduct becomes problematic, because it doesn't look as if Sally had improper intent. Sally had to disclose this information to Laura because of business considerations. She wanted Laura's advice about patenting this new technology. She did not have the scienter of your typical 10b-5 tipper. So I conclude that Sally is going to be liable under 10b-5 because of her own trading based on this insider information, not because she tipped this information to Laura, even though Laura did trade. Next, we focus on 16b, and here again, up front, I give you about as short a definition of 16b as you could possibly imagine writing. I indicate that 16b protects against insider trading that results in short swing profits. Now, let me pause for a second and ask you a rhetorical question. Do you personally think that this answer would be better if I figured out a way to string out the definition of Rule 16b to cover a paragraph or two? Right, I don't think so either. So, now we focus on the actual details. Sally bought this Chipco stock shortly after March 1698, when the stock was selling for $10 on the open market. She is an insider because she is the vice president and because she has privileged information. The stock price doubled on April 12th, and although it did fluctuate down to 11 later that month, it was worth $20 when Sally sold it in September 98. She doubled her investment in less than the statutory time, and that makes her liable under 16b. Yes, it really is that simple. So let's move on to consider Laura. We consider Laura first under 10b-5. She's an insider for 10b-5 purposes in a couple of different ways. She's a patent lawyer who was hired to give advice about the Chipco situation, and she had more than 10% of the outstanding shares. So she faces 10b-5 liability as a tipper for disclosing this privileged information to Arnold. And she doesn't face liability as a tippee because she obtained the information in the normal course of business. And I incorporate by reference next the materiality, reliance, and interstate commerce elements. But here, what makes Laura different from our first defendant is she has scienter, and the analysis in the last 10b-5 paragraph establishes that. I conclude that Laura is going to be liable under 10b-5. Next, we turn to 16b, and we consider Laura. Here, her situation, again, is identical to that of our first defendant, Sally. And also, it's the same as Arnold. We're going to talk about him in the next section. Laura also doubled her money in less than 6 months. And here, she's going to be liable, but only for the short swing profits that she made within that 6-month window. Fair enough. Now we turn to Arnold. Arnold's situation also is simple. We focus on Arnold with regard to 10b-5. Here, his liability comes from his status as a tippee. I explain the disclosure, and although Arnold personally is not an insider, he certainly did know that he was getting inside information from a bona fide insider who appeared to be acting solely for his benefit. So, his behavior establishes materiality, and it also establishes reliance. His phone call satisfies the interstate commerce requirement, and so the bottom line, Arnold is liable under 10b-5. So next let's consider 16b. Here Arnold's liability is identical to that of Sally and Laura. He bought and sold stock within 6 months. He doubled his money based on inside information. Therefore, he is liable. So now let me pause for just a moment before I go through the analysis of Chipco, our last defendant. I have little doubt that some of you were able to organize your answers to these questions by focusing on the elements for all of the defendants, not just for the first one. And that's fine. My only concern about that approach is that if you fragment this answer too thoroughly, it becomes difficult for your legal analysis to be as sharp as it would be otherwise. I have compressed the elements in this answer in a way that I don't in every answer because I think that this approach affords for a stronger display of legal reasoning in a context that makes it easy for our disinterested chain-smoking solo practitioner to see that we know what we're doing. But again, I want to counsel you that there's room for reasonable people to differ about just about every step in the process of producing a good answer. By this point, you already know the approach that I am presenting is consistent across subjects, and you may agree or disagree with some of the legal bottom lines that I reach, but at this point, I'm confident that you appreciate the importance of organization and analysis. Okay, now let's focus on Chipco's possible violations of the securities laws. First, we look at 10b-5. The corporation's possible liability depends on whether or not it misled the public about any of its work on this breakthrough technology. We are told about 2 different public statements that Chipco made about these facts, and we will analyze each of them separately. We'll conclude no liability. The first press release was issued shortly after April 10, 98. I quote from it, and I indicate that the context of this press release was responding to a financial newspaper, and the information in this press release was material, and traders relied on it. But the good news for the prospective defendant Chipco is the information was all truthful. Sally knew that additional testing was required, and Chipco itself wasn't sure that the technology was viable for another 4 months. So then we look at the second press release, and here it announced its breakthrough on August 20, 1998. And this, too, was a truthful statement. The price went back up, but the public learned the information all at the same time as required under the securities laws. And Chipco didn't do anything wrong. Therefore, no liability. And then, finally, we turn to 16b. Here, we acknowledge that Chipco's been buying big wads of its own shares when the price went up. But it doesn't look as if Chipco sold any of this stock. Therefore, no short swing profits. Its equity has gone up because of these purchases, but it has not engaged in any insider trading. Therefore, Chipco won't be liable under Rule 16b either. And that wraps up a consideration of a very useful and a very straightforward and, undeniably, a simple securities law question.